Chapter 2, Part 2 of An Essay on the Trial by Jury. This is the LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Beth Ann. Trial by Jury by Lysander Spooner. Chapter 2, Part 2. Whether Magna Carta allowed of any other trial than by jury. The question here arises, whether legem terrae did not allow of some other mode of trial than that by jury. The answer is, that, at the time of Magna Carta, it is not probable, for the reasons given in the note, that legem terrae authorized in criminal cases any other trial than the trial by jury. But, if it did, it certainly authorized none but the trial by battle, the trial by ordeal, and the trial by compurgators. These were the only modes of trial, except by jury, that had been known in England, in criminal cases for some centuries previous to Magna Carta. All of them had become nearly extinct at the time of Magna Carta, and it is not probable that they were included in legem terrae, as that term is used in that instrument. But if they were included in it, they have now been long obsolete, and were such as neither this nor any future age will ever return to. Note: the trial by battle was one in which the accused challenged his accuser to single combat, and staked the question of his guilt or innocence on the result of the duel. This trial was introduced into England by the Normans, within 150 years before Magna Carta. It was not very often resorted to, even by the Normans themselves; probably never by the Anglo-Saxons, unless in their controversies with the Normans. It was strongly discouraged by some of the Norman princes, particularly by Henry II., by whom the trial by jury was especially favored. It is probable that the trial by battle, so far as it prevailed at all in England, was rather tolerated as a matter of chivalry, than authorized as a matter of law. At any rate, it is not likely that it was included in the legem terrae of Magna Carta, although such duels have occasionally occurred since that time, and have, by some, been supposed to be lawful. I apprehend that nothing can be properly said to be a part of lex terrae, unless it can be shown either to have been of Saxon origin, or to have been recognized by Magna Carta. The trial by ordeal was of various kinds. In one ordeal the accused was required to take hot iron in his hand; in another to walk blindfold among red-hot plowshares; in another to thrust his arm into boiling water; in another to be thrown, with his hands and feet bound, into cold water; in another to swallow the morsel of execration, in the confidence that his guilt or innocence would be miraculously made known. This mode of trial was nearly extinct at the time of Magna Carta, and it is not likely that it was included in legem terrae, as that term is used in that instrument. This idea is corroborated by the fact that the trial by ordeal was specially prohibited only 4 years after Magna Carta, by act of Parliament in 3 Henry III., according to Sir Edward Coke, or rather by an order of the king in council. 3 Blackstone 345 note. I apprehend that this trial was never forced upon accused persons, but was only allowed to them as an appeal to God, from the judgment of a jury. Note within note. Hallam says, "It appears as if the ordeal were permitted to persons already convicted by the verdict of a jury." 2 Middle Ages 446 note. End of note. The trial by compurgators was one in which, if the accused could bring 12 of his neighbors, who would make oath that they believed him innocent, he was held to be so. It is probable that this trial was really the trial by jury, or was allowed as an appeal from a jury. It is wholly improbable that two different modes of trial, so nearly resembling each other as this and the trial by jury do, should prevail at the same time, and among a rude people, whose judicial proceedings would naturally be of the simplest kind. But if this trial really were any other than the trial by jury, it must have been nearly or quite extinct at the time of Magna Carta, and there is no probability that it was included in legem terrae. For all practical purposes of the present day, therefore, it may be asserted that Magna Carta allows no trial whatever but trial by jury, whether Magna Carta allowed sentence to be fixed otherwise than by the jury. Still another question arises on the words legem terrae, viz., whether, in cases where the question of guilt was determined by the jury, the amount of punishment may not have been fixed by legem terrae, the common law, instead of its being fixed by the jury. I think we have no evidence whatever that, at the time of Magna Carta, or indeed at any other time, lex terrae, the common law, fixed the punishment in cases where the question of guilt was tried by a jury, or indeed that it did in any other case. Doubtless certain punishments were common and usual for certain offenses, but I do not think it can be shown that the common law, the lex terrae, which the king was sworn to maintain, required any one specific punishment, or any precise amount of punishment, for any one specific offense. If such a thing be claimed, it must be shown, for it cannot be presumed. In fact, the contrary must be presumed, because, in the nature of things, the amount of punishment proper to be inflicted in any particular case is a matter requiring the exercise of discretion at the time, in order to adapt it to the moral quality of the offense, which is different in each case, varying with the mental and moral constitution of the offenders, and the circumstances of temptation or provocation. And Magna Carta recognizes this principle distinctly, as has before been shown, in providing that freemen, merchants, and villeins shall not be amerced for a small crime, but according to the degree of the crime, and for a great crime in proportion to the magnitude of it; and that none of the aforesaid amercements shall be imposed or assessed but by the oaths of honest men of the neighborhood; and that earls and barons shall not be amerced but by their peers, and according to the quality of the offense. All this implies that the moral quality of the offense was to be judged of at the trial, and that the punishment was to be fixed by the discretion of the peers, or jury, and not by any such unvarying rule as a common law rule would be. I think, therefore, it must be conceded that, in all cases tried by a jury, Magna Carta intended that the punishment should be fixed by the jury, and not by the common law, for these several reasons. First, it is uncertain whether the common law fixed the punishment of any offense whatever. Second, the words per judicium parium suorum, according to the sentence of his peers, imply that the jury fixed the sentence in some cases tried by them; and if they fixed the sentence in some cases, it must be presumed they did it in all, unless the contrary be clearly shown. Third, the express provisions of Magna Carta, before adverted to, that no amercements or fines should be imposed upon freemen, merchants, or villeins, but by the oath of honest men of the neighborhood, and according to the degree of the crime; and that earls and barons should not be amerced but by their peers, and according to the quality of the offense, proves that, at least, there was no common law fixing the amount of fines, or if there were, that it was to be no longer in force. And if there was no common law fixing the amount of fines, or if it was to be no longer in force, it is reasonable to infer, in the absence of all evidence to the contrary, either that the common law did not fix the amount of any other punishment, or that it was to be no longer enforced for that purpose. Note: Coke attempts to show that there is a distinction between amercements and fines, admitting that amercements must be fixed by one's peers, but claiming that fines may be fixed by the government. 2 Institutes 27:8, Coke's Reports 38. But there seems to have been no ground whatever for supposing that any such distinction existed at the time of Magna Carta. If there were any such distinction at the time of Coke, it had doubtless grown up within the 4 centuries that had elapsed since Magna Carta, and is to be set down as one of the numberless inventions of government for getting rid of the restraints of Magna Carta, and for taking men out of the protection of their peers, and subjecting them to such punishments as the government chooses to inflict. The first statute of Westminster, passed 60 years after Magna Carta, treats the fine and amercements as synonymous, as follows: "Forasmuch as the common fine and amercement of the whole county and ire of the justices for false judgments, or for other trespass, is unjustly assessed by sheriffs and barrators in the shires, it is provided, then, and the king wills, that from henceforth such sums shall be assessed before the justices in ire, afore their departure, by the oath of knights and other honest men," etc. 3 Edward I, chapter 18, 1275. And in many other statutes passed after Magna Carta, the terms fine and amercement seem to be used indifferently, in prescribing the punishment for offenses. As late as 1461, 246 years after Magna Carta, the statute 1 Edward IV, chapter 2, speaks of fines, ransoms, and amercements, as being levied upon criminals, as if they were the common punishments of offenses. Statute 2 and 3 Philip and Mary, chapter 8, uses the terms fines, forfeitures, and amercements 5 times. 1555. Statute 5 Elizabeth, chapter 13, section 10, uses the terms fines, forfeitures, and amercements. That amercements were fines or pecuniary punishments inflicted for offenses is proved by the following statutes, all supposed to have been passed within 115 years after Magna Carta, which speak of amercements as a species of judgment or punishment, and as being inflicted for the same offenses as other judgments. Thus one statute declares that a baker, for default in the weight of his bread, ought to be amerced, or suffer the judgment of the pillory; and that a brewer, for selling ale contrary to the assize, ought to be amerced, or suffer the judgment of the tumbril. 51 Henry III, statute 6, 1266. Among the statutes of uncertain date, but supposed to be prior to Edward III, 1326, are the following. Chapter 6 provides that, if a brewer break the assize, fixing the price of ale, the first, second, and third time he shall be amerced, but the fourth time he shall suffer judgment of the pillory, without redemption. Chapter 7 provides that a butcher that selleth swine's flesh measled, or flesh dead of the murrain, or that buyeth flesh of Jews, and selleth the same unto Christians, after he shall be convicted thereof, for the first time he shall be grievously amerced, the second time he shall suffer judgment of the pillory, and the third time he shall be imprisoned and make fine, and the fourth time he shall forswear the town. Chapter 10, a statute against forestalling, provides that he that is convicted thereof the first time shall be amerced, and shall lose the thing so bought; and that according to the custom of the town, he that is convicted the second time shall have judgment of the pillory; at the third time he shall be imprisoned and make fine; The fourth time he shall abjure the town. And this judgment shall be given upon all manner of forestallers, and likewise upon them that have given them counsel, help, or favor. First Roughhead Statutes, 187, 188. Statutes of the Realm, 203. Under the Saxon laws, fines payable to the injured party seem to have been the common punishments for all offenses. Even murder was punishable by a fine payable to the relatives of the deceased. The murder of the king, even, was punishable by fine. When a criminal was unable to pay his fine, his relatives often paid it for him. But if it were not paid, he was put out of the protection of the law, and the injured parties, or in the case of murder, the kindred of the deceased, were allowed to inflict such punishment as they pleased. And if the relatives of the criminal protected him, it was lawful to take vengeance on them also. Afterwards the custom grew up of exacting fines also to the king as a punishment for offenses. Note: 1 Hume, Appendix 1. And this latter was, doubtless, the usual punishment at the time of Magna Carta, as is evidenced by the fact that for many years immediately following Magna Carta, nearly or quite all statutes that prescribed any punishment at all, prescribed that the offender should be grievously immersed, or pay a great fine to the king, or a grievous ransom, with the alternative in some cases, perhaps understood in all, of imprisonment, banishment, or outlawry, in case of non-payment. Note: Blackstone says, "Our ancient Saxon laws nominally punished theft with death, if above the value of 12 pence; but the criminal was permitted to redeem his life by a pecuniary ransom, as among their ancestors, the Germans, by a stated number of cattle. But in the 9th year of Henry I., 1109, this power of redemption was taken away, and all persons guilty of larceny above the value of 12 pence were directed to be hanged, which law continues in force to this day." 4th Blackstone, 238. I give this statement of Blackstone, because the latter clause may seem to militate with the idea, which the former clause corroborates, viz., that at the time of Magna Carta, fines were the usual punishments of offenses. But I think there is no probability that a law so unreasonable in itself, unreasonable even after making all allowance for the difference in the value of money, and so contrary to immemorial custom, could or did obtain any general or speedy acquiescence among a people who cared little for the authority of kings. Madox, writing of the period from William the Conqueror to John, says, "The amercements in criminal and common pleas, which were wont to be imposed during this first period and afterwards, were of so many several sorts, that it is not easy to place them under distinct heads. Let them, for method's sake, be reduced to the heads following: Amercements for or by reason of murders and manslaughters, for misdemeanors, for disseisinge, for recreancy, for breach of assize, for defaults, for non-appearance, for false judgment, and for not making suit, or hue and cry. To them may be added miscellaneous amercements, for trespasses of divers kinds." First Madox History of the Exchequer, 542. Judging, therefore, from the special provisions in Magna Carta requiring fines or amercements to be imposed only by juries, without mentioning any other punishments, judging also from the statutes which immediately followed Magna Carta, it is probable that the Saxon custom of punishing all, or nearly all, offenses by fines, with the alternative to the criminal being imprisoned, banished, or outlawed, and exposed to private vengeance in case of non-payment, continued until the time of Magna Carta, and that in providing expressly that fines should be fixed by the juries, Magna Carta provided for nearly or quite all the punishments that were expected to be inflicted; that if there were to be any others, they were to be fixed by the juries; and consequently that nothing was left to be fixed by legem terrae. But whether the common law fixed the punishment of any offenses or not is a matter of little or no practical importance at this day, because we have no idea of going back to any common law punishments of 600 years ago, if, indeed, there were any such at the time. It is enough for us to know, and this is what it is material for us to know, that the jury fixed the punishments, in all cases, unless they were fixed by the common law; that Magna Carta allowed no punishments to be prescribed by statute, that is, by the legislative power, nor in any other manner by the king, or his judges, in any case whatever; and consequently that all statutes prescribing particular punishments for particular offenses, or giving the king's judges any authority to fix punishments, were void. If the power to fix punishments had been left in the hands of the king, it would have given him a power of oppression, which was liable to be greatly abused, which there was no occasion to leave with him, and which would have been incongruous with the whole object of this chapter of Magna Carta, which object was to take all discretionary or arbitrary power over individuals entirely out of the hands of the king, and his laws, and entrust it only to the common law and the peers, or jury, that is, the people. What lex terrae did authorize. But here the question arises, what then did legem terrae authorize the king, that is, the government, to do in the case of an accused person, if it neither authorized any other trial than that by jury, nor any other punishments than those fixed by juries? The answer is, that, owing to the darkness of history on the point, it is probably wholly impossible at this day to state, with any certainty or precision, anything whatever that the legem terrae of Magna Carta did authorize the king, that is, the government, to do, if indeed it authorized him to do anything, in the case of criminals, other than to have them tried and sentenced by their peers for common law crimes, and to carry that sentence into execution. The trial by jury was a part of legem terrae, and we have the means of knowing what the trial by jury was. The fact that the jury were to fix the sentence implies that they were to try the accused; otherwise they could not know what sentence, or rather any sentence, ought to be inflicted upon him. Hence it follows that the jury were to judge of everything involved in the trial; that is, they were to judge of the nature of the offense, of the admissibility and weight of testimony, and of everything else whatsoever that was of the essence of the trial. If anything whatever could be dictated to them, either of law or evidence, the sentence would not be theirs, but would be dictated to them by the power that dictated to them the law or evidence. The trial and sentence, then, were wholly in the hands of the jury. We also have sufficient evidence in the nature of the oath administered to juries in criminal cases. It was simply that they would neither convict the innocent nor acquit the guilty. This was the oath in the Saxon times, and probably continued to be until Magna Carta. We also know that, in the case of conviction, the sentence of the jury was not necessarily final, that the accused had the right of appeal to the king and his judges, and to demand either a new trial or an acquittal, if the trial or conviction had been against law. So much, therefore, of the legem terrae of Magna Carta we know with reasonable certainty. We also know that Magna Carta provides that no bailiff (balivus) shall hereafter put any man to his law, put him on trial, on his single testimony, without credible witnesses brought to support it. Coke thinks that under this word balivus, in this act, is comprehended every justice, minister of the king, steward of the king, steward, and bailiff. 2 Institutes 44. And in support of this idea he quotes from a very ancient law book, called the Mirror of Justices, written in the time of Edward I., within a century after Magna Carta. But whether this were really a common law principle, or whether the provision grew out of that jealousy of the government which, at the time of Magna Carta, had reached its height, cannot perhaps now be determined. We also know that, by Magna Carta, amercements or fines could not be imposed to the ruin of the criminal; that, in the case of a freeman, his contenement, or means of subsisting in the condition of a freeman, must be saved to him; that, in the case of a merchant, his merchandise must be spared; and in the case of a villein, his wainage, or plough tackle, and carts. This also is likely to have been a principle of the common law, inasmuch as, in that rude age, when the means of getting employment as laborers were not what they are now, the man and his family would probably have been liable to starvation, if these means of sustenance had been taken from him. We also know, generally, that at the time of Magna Carta, all acts intrinsically criminal, all trespasses against persons and property, were crimes, according to lex terrae, or the common law. Beyond the points now given, we hardly know anything, probably nothing with certainty, as to what the legem terrae of Magna Carta did authorize, in regard to crimes. There is hardly anything extant that can give us any real light on the subject. It would seem, however, that there were, even at that day, some common law principles governing arrests, and some common law forms and rules as to holding a man for trial, by bail or imprisonment, putting him on trial, such as by indictment or complaint, summoning and impanelling jurors, etc., etc. Whatever these common law principles were, Magna Carta requires them to be observed, for Magna Carta provides for the whole proceedings, commencing with the arrest, no freeman shall be arrested, etc., and ending with the execution of the sentence; and it provides that nothing shall be done by the government from beginning to end, unless according to the sentence of the peers, or legem terrae, the common law. The trial by peers was a part of legem terrae, and we have seen that the peers must necessarily have governed the whole proceedings at the trial. But all the proceedings for arresting the man and bringing him to trial must have been had before the case could come under the cognizance of the peers, and they must, therefore, have been governed by other rules than the discretion of the peers. We may conjecture, although we cannot perhaps know with much certainty, that lex terrae, or common law, governing these other proceedings, was somewhat similar to the common law principles on the same points at the present day. Such seem to be the opinions of Coke, who says that the phrase nisi per legem terrae means unless by due process of law. Thus he says, nisi per legem terrae, but by the law of the land. For the true sense and exposition of these words, see the statute of 37 Edward III, chapter 8, where the words, by the law of the land, are rendered, without due process of law. For there it is said, though it be contained in the Great Charter, that no man be taken, imprisoned, or put out of his freehold, without process of law, that is, by indictment or presentment of good and lawful men, where such deeds be done in due manner, or by writ original of the common law, without being brought in to answer but by due process of the common law. No man be put to answer without presentment before justices, or thing of record, or by due process, or by writ original, according to the old law of the land. 2 Institutes 50. The foregoing interpretations of the word nisi per legem terrae are corroborated by the following statutes, enacted in the next century after Magna Carta: That no man from henceforth shall be attached by any accusation, nor forejudged of life or limb, nor his land, tenements, goods, nor chattels, seized into the king's hands, against the form of the Great Charter, and the law of the land. Statute 5, Edward III, chapter 9, 1331. Whereas it is contained in the Great Charter of the franchises of England, that none shall be imprisoned, nor put out of his freehold, nor of his franchises, nor free customs, unless it be by the law of the land, is accorded, assented, and established, that from henceforth none shall be taken by petition, or suggestion made to our lord the king, or to his council, unless it be by indictment or presentment of good and lawful people of the same neighborhood where such deeds be done in due manner, or by process made by writ original at the common law; nor that none be put out of his franchises, nor of his freehold, unless he be duly brought into answer, and forejudged of the same by the course of the law; and if anything be done against the same, it shall be redressed and holden for none. Statute 25, Edward III, chapter 4, 1350. That no man, of what estate or condition that he be, shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death, without being brought in answer by due process of law. Statute 28, Edward III, chapter 3, 1354. That no man be put to answer without presentment before justices, or matter of record, or by due process and writ original, according to the old law of the land; and if anything from henceforth be done to the contrary, it shall be void in law, and holden for error. Statute 42, Edward III, chapter 3, 1368. The foregoing interpretation of the words nisi per legem terrae, that is, by due process of law, including indictment, etc., has been adopted as the true one by modern writers and courts, as for example by Kent, 2 Commentaries, 13; Story, 3 Commentaries, 661; and the Supreme Court of New York, 19 Wendell, 676, 4 Hill, 146. The Fifth Amendment to the Constitution of the United States seems to have been framed on the same idea, inasmuch as it provides that "no person shall be deprived of life, liberty, or property, without due process of law." Note: Coke, in his exposition on the words legem terrae, gives quite in detail the principles of the common law governing arrests, and takes it for granted that the words nisi per legem terrae are applicable to arrests, as well as to the indictment, etc. 2 Institutes 51, 52. Whether the word vel should be rendered by or by and. Having thus given the meanings, or rather the applications, which the words vel per legem terrae will reasonably, and perhaps must necessarily, bear, it is proper to suggest that it has been supposed by some that the word vel, instead of being rendered by or, as it usually is, ought to be rendered by and, inasmuch as the word veil is often used for it, and the whole phrase nisi per judicium parium suorum vel per legem terrae, which would then read, unless by the sentence of his peers, and the law of the land, would convey a more intelligible and harmonious meaning than it otherwise does. Blackstone suggests that this may be the true reading. Charters, p. 41. Also, Mr. Hallam, who says, Nisi per legale judicium parium suorum, vel per legem terrae. Several explanations have been offered of the alternative clause, which some have referred to judgment by default, or demurrer; others to the process of attachment for contempt. Certainly there are many legal procedures besides trial by jury, through which a party's goods or person may be taken. But one may doubt whether these were in contemplation of the framers of Magna Carta. In an entry of the charter of 1217, by a contemporary hand, preserved in the town clerk's office in London, called Liber Customarum et Regum Antiquorum, a various reading et per legem terrae occurs. Blackstone's Charters, p. 41. And the word vel is so frequently used for et, that I am not wholly free from the suspicion that it was so intended in this place. The meaning will be, that no person shall be disseized, etc., except upon a lawful cause of action, found by the verdict of a jury. This really seems as good as any of the disjunctive interpretations, but I do not offer it with much confidence. 2 Hallam's Middle Ages, chapter 8, part 2, page 449, and note. Note: I cite the above extract from Mr. Hallam, solely for the sake of his authority for rendering the word vel by and not by any means for the purpose of endorsing the opinion he suggests, that legem terrae authorized judgments by default or demurrer, without the intervention of a jury. He seems to imagine that lex terrae, the common law, at the time of Magna Carta, included everything, even at the practice of courts, that is, at this day, called by the name of common law; whereas much of what is now called common law has grown up, by usurpation, since the time of Magna Carta, in palpable violation of the authority of that charter. He says, certainly there are many legal procedures besides trial by jury, through which a party's goods or person may be taken. Of course there are now many such ways in which a party's goods or person are taken, besides by the judgment of a jury; but the question is, whether such takings are not in violation of Magna Carta. He seems to think that, in cases of judgment by default or demurrer, there is no need of a jury, and thence to infer that legem terrae may not have required a jury in those cases. But this opinion is founded on the erroneous idea that juries are required only for determining contested facts, and not for judging of the law. In case of default, the plaintiff must present a prima facie case before he is entitled to a judgment; and Magna Carta, supposing it to require a jury trial in civil cases, as Mr. Hallam assumes that it does, as much requires that this prima facie case, both law and fact, be made out to the satisfaction of a jury, as it does that a contested case shall be. As for a demurrer, the jury must try a demurrer, having the advice and assistance of the court of course, as much as any other matter of law arising in a case. Mr. Hallam evidently thinks there is no use for a jury, except where there is a trial, meaning thereby a contest on matters of fact. His language is, that there are many legal procedures besides trial by jury, through which a party's goods or person may be taken. Now Magna Carta says nothing of trial by jury, but only of the judgment or sentence of a jury. It is only by inference that we come to the conclusion that there must be a trial by jury. Since the jury alone can give the judgment, or sentence, we infer that they must try the case, because otherwise they would be incompetent, and would have no moral right to give judgment. They must therefore examine the grounds, both of law and of fact, or rather try the grounds, of every action whatsoever, whether it be decided on default, demurrer, or otherwise, and render their judgment or sentence thereon, before any judgment can be a legal one, on which to take a party's goods or person. In short, the principle of Magna Carta is, that no judgment can be valid against a party's goods or person, not even a judgment for costs, except a judgment rendered by a jury. Of course a jury must try every question, both of law and fact, that is involved in rendering of that judgment. They are to have the assistance and advice of the judges, so far as they desire them, but the judgment itself must be theirs, and not the judgment of the court. As to process of attachment for contempt, it is of course lawful for a judge, in his character of a peace officer, to issue a warrant for the arrest of a man guilty of contempt, as he would for the arrest of any other offender, and hold him to bail, or, in default of bail, commit him to prison, to answer for his offense before a jury. Or he may order him into custody without a warrant when the offense is committed in the judge's presence. But there is no reason why a judge should have the power of punishing for contempt any more than for any other offense; and it is one of the most dangerous powers the judge can have, because it gives him absolute authority in a court of justice, and enables him to tyrannize as he pleases over parties, counsel, witnesses, and jurors. If a judge have power to punish for contempt, and to determine for himself what is a contempt, the whole administration of justice, or injustice if he chooses to make it so, is in his hands, and all the rights of jurors, witnesses, counsel, and parties are held subject to his pleasure, and can be exercised only agreeably to his will. He can of course control the entire proceedings in, and consequently the decision of, every cause, by restraining and punishing everyone, whether party, counsel, witnesses, or juror, who presumes to offer anything contrary to his pleasure. This arbitrary power, which has been usurped and exercised by judges to punish for contempt, has undoubtedly had much to do in subduing counsel into those servile, obsequious, and cowardly habits which so universally prevail among them, and which have not only cost so many clients their rights, but have also cost the people so many of their liberties. If any summary punishment for contempt be ever necessary, as it probably is not, beyond exclusion for the time being from the court room, which should be done, not as a punishment, but for self-protection and the preservation of order, the judgment for it should be given by the jury, where the trial is before a jury and not by the court, for the jury, and not the court, are really the judges. For the same reason, exclusion from the court room should be ordered only by the jury in cases when the trial is before a jury, because they, being the real judges and triers of the cause, are entitled, if anybody, to the control of the court room. In appeal courts, where no juries sit, it may be necessary, not as a punishment but for self-protection and the maintenance of order, that the court should exercise the power of excluding a person, for the time being, from the court room. But there is no reason why they should proceed to sentence him as a criminal, without his being tried by a jury. If the people wish to have their rights respected and protected in courts of justice, it is manifestly of the last importance that they jealously guard the liberty of parties, counsel, witnesses, and jurors, against all arbitrary power on the part of the court. Certainly Mr. Hallam may very well say, that one may doubt whether these, the several cases he has mentioned, were in contemplation of the framers of Magna Carta; that is, as exceptions to the rule requiring that all judgments that are to be enforced, against a party's goods or person, be rendered by a jury. Again, Mr. Hallam says, if the word vel be rendered by and, the meaning will be, that no person shall be disseized, etc., except upon a lawful cause of action. This is true, but it does not follow that any cause of action, founded on statute only, is therefore a lawful cause of action, within the meaning of legem terrae, or the common law. Within the meaning of the legem terrae of Magna Carta, nothing but a common law cause of action is a lawful one. The idea that the word vel should be rendered by and, is corroborated, if not absolutely confirmed, by the following passage in Blackstone, which has before been cited. Speaking of the trial by jury, as established by Magna Carta, he calls it "a privilege which is couched in almost the same words with that of the Emperor Conrad 200 years before: Nemo beneficium suam perdat, nisi secundum consuetudinem antecessorum nostrorum, et judicium parium suorum. No one shall lose his estate, unless according to the custom of her ancestors, and the judgment of his peers." 3 Blackstone, 350. If the word vel be rendered by and, as I think it must be, at least in some cases, this chapter of Magna Carta will then read that no freeman shall be arrested or punished, unless according to the sentence of his peers and the law of the land. The difference between this reading and the other is important. In the one case, there would be, at first view, some color of ground for saying that a man might be punished in either of two ways, viz., according to the sentence of his peers, or according to the law of the land. In the other case, it requires both the sentence of his peers and the law of the land, common law, to authorize his punishment. If this latter reading be adopted, the provision would seem to exclude all trials except trial by jury, and all causes of action except those of the common law. But I apprehend the word vel must be rendered both by and by or, that in cases of a judgment it should be rendered by and, so as to require the concurrence both of the judgment of the peers and the law of the land, to authorize the king to make execution upon a party's goods or person; but that in cases of arrest and imprisonment, simply for the purpose of bringing a man to trial, vel should be rendered by or, because there can have been no judgment of a jury in such a case, and the law of the land must therefore necessarily be the only guide to, and restraint upon, the king. If this guide and restraint were taken away, the king would be invested with an arbitrary and most dangerous power in making arrests, and confining to prison, under pretense of an intention to bring to trial. Having thus examined the language of this chapter of Magna Carta, so far as it relates to criminal cases, its legal import may be stated as follows, viz.: No freeman shall be arrested or imprisoned or deprived of his freehold, or his liberties, or free customs, or be outlawed, or exiled, or in any manner destroyed, harmed, nor will we, the king, proceed against him, nor send any one against him, by force or arms, unless according to, that is, in execution of, the sentence of his peers, and, or, as the case may require, the common law of England, as it was at the time of Magna Carta, in 1215. End of chapter 2, part 2.